Hello, everybody. Traps in the green card process. We have a great topic. As a matter of fact, this topic is
We're gonna have some fun.
Yes, this is something that this is what we do every day, is scenarios in gray areas that it doesn't happen to everybody, but it happens a lot here in this office because we obviously handle difficult cases. People come to us from other experiences and they hear about our firm and they said, well, help me out. And we kind of dig deep into the traps in the green card process. I'm Sam Shihab.
I'm Brian Burke.
And we are from the law firm of Sam Shihab and Associates. We practice immigration law throughout the U.S. and throughout the world. We spend a lot of time doing employment immigration law. And when we come back, we're going to talk about traps in the green card process. All right, so great. What is trap? What do you mean by traps in the green card process?
I don't know. So we talked. This is a fun conversation going into this presentation for sure. And I kind of describe these things as the things that keep me up at night. I mean, because in immigration law, in the U.S. immigration law anyway, there are questions out there. There's so many unknowns, right? And there's gray areas, things where the answers aren't clear, and these are the kind of things I'm thinking of, where the government could decide they want to really zero in on something, and everybody could be, in theory, caught off guard because, people get used to doing things one way, and the government doesn't care because they're happy, but then they have a meeting somewhere, there's a change in their policy, and they start zeroing in on an issue. So
scenarios that could bring into jeopardy the approvability of the green card process that is kind of you're blindsided to it. You don't normally see that, but they kind of come up. Can they make this immigration law more complicated? Are you kidding me?
When I try to explain my job to people, I mention our reference book, Kurzban's. Now, when I started here, it was that thick. Now it's that thick. And they're talking about another volume of it now.
Now it's a two-volume book.
A two-volume book.
Now it's a two-volume book.
So yes, it's gotten more complicated. Never a short answer from Brian.
Yes. It has gotten way too complicated. It needs to really, it's worse than the IRS code now, to be honest with you. So let's talk about the first trap, the first issue that we are going to talk about and share with people and discuss.
Yeah. So this scenario is, I'm applying for a green card. My labor certification, my perm and I-140 were done 10 years ago, and now I get paid significantly more than what is on that labor certification in I-140 that's so old.
Everybody applying for a green card have this issue.
Yeah.
Everybody applying for a green card has this issue from a backlogged country.
Yeah.
Everybody. And this issue, the law is not clear on it to some extent.
Yeah.
You got a perm labor certification, and then 10 years later, it has a salary in it, and then 10 years later, they're talking about giving you a green card, and you've listed a salary that was given 10 years ago.
Yeah. Practically speaking, in my experience, I found that USCIS considers, your labor certification salary from, 10 years ago to be a floor, a bare minimum. And they typically don't care that your salary is increased. Fundamentally, they're interested in whether it's the same job, because 10 years is a long time. Maybe the job market has changed, but certainly the wages for a lot of occupations have changed. And, it's every now and again, I know sometime earlier this year, you got questioned at an interview by an officer on that subject, didn't you?
Oh yeah, it got questioned, and it was like when on the supplement J when it says offered wage, and this was a situation where the supplement J was written by counsel for a company who was not our office. And we were representing the beneficiary, and the council listed the offered wage as the wage on the labor certification, which was certified 10 years ago. And the officer said, "You're only making $70,000 a year," and the beneficiary said, "No, I'm making $110,000 now." And she took an issue with the wage listed not matching the wage paid today. And I explained to her that the instructions were not clear exactly whether this is related to what the labor certification wage, offered wage, or is it what the actual wage. We can certainly amend it or send you an updated one. It was not intended to trick or mislead. My client is paid substantially higher than the labor certification number. To me, that is not the bigger problem, although there is a problem when the wage is significantly higher. So when you have a wage that is 3 times, threefold, or fourfold, it's listed as 70,000. This guy is making 280,000. That's a problem.
Yeah, well, that starts to beg the question. Are you still really doing the same job that you are in this labor certification? And that's fundamental. I mean, I've had to tell some people,
that's a problem.
That honestly, if it doesn't sound like you're doing the job that's on your I-140 anymore, and you may have to do another labor certification.
You know what I tell people? Take that wage, the year it was given, and apply a cost of living increase on it, which is usually runs between 2.5% to 4%, depending on the year. Apply that till today. You have a number. Compare it to the number that you're paid, and that should give you a good indicator of whether you have an issue or you don't have an issue.
Yeah.
Now, the bigger problem I have is when the wage paid the year that the labor certification was filed was already higher paid to the employee. So they list $70,000 as a prevailing wage, offered wage is $70,000, but they're already paying this guy $110,000.
Yeah, no.
That's a bigger problem.
Yeah, I mean that's a problem which you occasionally see, and the employer has something to answer for. So how were you seeking permanent employment for this person pursuant to that lower offer when you're actually paying them this?
Because you're advertising for this position as part of the labor certification is that you have to prove that there's no qualified U.S. workers available, willing, ready, and able within the geographic area in good faith.
Yeah.
In good faith. And did we violate the good faith standard by hiding what the employer really is willing to pay?
Yeah, and I mean these things. Well, I got to say, Sam, all these scenarios are super fact sensitive. We've helped people on the scenarios like this, in the past, and it's very sensitive to the facts. And if an officer brings up an issue, it's possible to basically sort of explain it away. But
it does begin with an intelligent labor. Everybody can get a labor certification certified. It's getting that labor certification through the trip. The journey from certification into the green card is really where the trick is. And early intervention with a qualified attorney that tells the employer, one of the things that I do, one of the things that you do in this office is we pull the wage of the employee actually and look at it. And we will alert the employer if there's something that doesn't make sense. For example, the attorney is not doing that and just basically throwing the prevailing wage the Department of Labor gives him as the offered wage automatically, you got a problem.
Yeah, I mean, one of the things I do early on in the perm process is, okay, tell me what you want to offer this person. Tell me what you want to offer them on a permanent basis. And the employers usually will say exactly what they're doing right now. And the inevitable question is that what you plan on having them do on a long-term basis? Because this is a process that could take years to a decade, depending upon where they're from. Yeah.
When a labor certification is opened in our office, and I'm sure a lot of good lawyers do the same thing. But I know not all the lawyers do it. When a labor certification is open in the office, there's a phone call made to the beneficiary. We will call them and we'll ask 5 or 6 critical questions. They're listed. It's not like we invent them. It's on the process. There's highlight 5 or 6 things we want to know. How much H-1B time you have left? Is there a status issue? Is there a degree issue? We collect some key information. What you're being paid now, so we understand from the get-go what's happening. So if that wage is substantially different from day one, I think there is a concern in the case. And if the wage, after you apply an adjusted cost of living factor, and also you can also add improved skills and knowledge, throughout the years. And if you are significantly higher, there's also a potential question is whether or not the job that you're doing is now different than the labor certification job, significantly, such that a new labor certification is required.
Yeah, and these questions, they come up. They don't come up, constantly, but one every 20 or so cases though, you get one of those interesting I-485 RFEs. They start asking about, hey, what kind of job do you have available for that thing? Is that
is director of IT similar job classification? Well, I was a software engineer when I did the perm. Now I am the director of IT. Well, okay, it all depends. Are you the director of IT in a large company or a company that has 3 people there? You could be director of yourself only. That's okay.
Yeah.
But that's not scary stuff. But if you're director of a large company, you have a team of 80 people under you. That's a different job.
Well, that is, you're right. I mean, that's the nuance. You know. Yeah.
All right, so moving on, the second trap that we deal with, this is something that you and I really had a good discussion not too long ago here in this office right here as we prepare for this presentation. Status violation after I-485 filing. This is a big one.
Well, yeah, so,
Like what? Give us an example, Brian.
Well, I think the only one that's, for people who aren't aware, basically once you file your I-485, having that case filed allows you to stay in the a timely filed I-485, of course, allows you to stay in the United States while the case is pending, and that's great. And really, the only way you can really get in a lot of trouble is, employment authorization violations.
There's other ones. Criminal.
Sure.
So you go through the interview, you have a fantastic interview, you get out that night, you're happy, you go to the bar, you drink one extra drink that you should have, and then you get in the car, God forbids, and you injure someone.
Yeah.
Right?
Yeah.
Now, or employment.
Yeah. So I was taking the much friendlier one. Yeah. It's you have your adjustment filed, your EAD lapsed, and you accrue more than 180 days of unauthorized employment, and you run afoul of INA 245K. So bottom line, Sam, is do you have, what do you do? Fundamentally, what I guess we're talking about is you've done anything that makes yourself eligible for a green card. Do you have an obligation to tell the government about it?
So we can probably, I would probably begin the analysis with whether or not this violation is going to be a deal breaker for my adjustment. That question has to be answered, right?
Oh, sure.
Although the obligation
is always
there, but for me, I need to know that. It's a no-brainer. You got to know that.
Yeah.
If the answer is no, it's a simple discussion. Just write them a letter, right?
Yeah.
Send it in the mail. Hey, I had a speeding ticket, or minor car accident, or I worked 3 days without EAD under INA 245K. I'm just fine. Okay.
Yeah, these are things they ask about in the I-485, and you have an obligation to basically let the government know about material changes that might affect your eligibility. Sure.
Now, even if you don't disclose it, Brian, I'm talking about violations that are not a deal breaker for the adjustment.
Yeah.
Even if you don't disclose it, I would say it's immaterial. Or is it not? Or is it material because now your adjustment of status application is incomplete? That's the question I'm posing to you.
Well, so if it is immaterial, if it doesn't affect your eligibility for adjustment, you disclose it. As you said. But if here's the problem. You can pat yourself on the back and say to yourself, that little status violation I had, even if it was one in the past or after filing your I-485, you just didn't disclose it to them. You can pat yourself on the back and say, that wasn't a problem. And the problem you have is if they know about it, then you have a problem. If you don't disclose something and they bring it up, you have a question of potentially of fraud or misrepresentation, because I think the government's more likely to think something's material than you, the individual who really wants that green card, is thinking about.
By disclosing it, if it is inconsequential, by disclosing it, you have resolved any future opportunity the government can come back at you later.
Yeah.
And that's a wonderful thing to do, because life is too short. I don't want to sleep every night thinking about what if they found out, when I'm going to go naturalize application, they're going to ask me, they're going to find this, they're going to ask me, did you disclose it? I'll just disclose it. I'll have a good qualified attorney of your choice to write a letter and say, here it is, and by the way, it's immaterial. It's not a bar to adjustment.
I've written a lot of those letters to people before.
Yeah, absolutely. So now, here comes the more difficult question that you and I had a good discussion about. You had a violation that is material, it's a deal breaker.
Let's come up with a hypothetical. You handed in fraudulent documents to the consulate when applying for your first visa. How about that?
Okay.
Yeah.
Okay, and you didn't disclose that.
Yeah.
And now you remembered.
Oh shoot. Yeah.
Or something happened after the I-44 file.
Sure.
You worked without authorization such that now it's over 180 days.
Yeah. You're ineligible. An attorney will tell you you're legally you're legally ineligible for adjustment.
So, as your lawyer, I must tell you, because it's my obligation that you must disclose it. But I must also tell you something else. I must also tell you that it's up to you whether you listen to me or not. It's up to you. I'm not your mom or your dad. I'm your lawyer.
Yeah.
You are your own person. You decide. I want to tell you, if you disclose it, you're going to get your green card denied. If you don't disclose it and they don't discover it later, you won't get your green card denied. But if you don't disclose it and they discover it later, you will get your green card denied. So if you disclose it before, you'll get your green card denied. If they find out after, you will get your green card denied. I will tell you that I am required as a lawyer under the bar, under my ethical duties, to request from you that you disclose it. I also, and every attorney will tell you that they cannot continue working with you if you decide not to disclose it.
That's the thing important for me. It'll usually comes in a letter from an attorney. Here's
but it's your decision whether you want to disclose it or not. And this is an issue, a very complicated issue between the client and the attorney, because as the attorney is obligated to help the client for as much as the attorney is capable of doing, the attorney cannot advance, go with you down the road at a certain point when the application is not truthful and you decide to continue in that direction.
Yeah, I mean, it stinks. I've upset people by saying I can't be involved in this case anymore, but it's,
But that doesn't change. That doesn't change the fact that you can still make the decision, say, Sam, you're a good lawyer. You helped me out. You explained it to me. I'm not going to do it. I'm going to say, well, I understand. I understand what you're saying as a human being. I don't agree with you as a lawyer. You can move on your own and not disclose it. That's your choice. And that's a tough one.
Yeah.
That's a tough one. Brian, what else do we have?
Sure. Here's a fun one. A labor certification question, and I actually had somebody really asking me about this in a consultation recently. It's the, let's talk about the easier one, progressively responsible experience for an EB2 green card based upon a bachelor's degree. So if you read the law carefully, an EB2 green card requires, based upon a bachelor's degree, requires a bachelor's degree and 5 years of progressively responsible post-graduation experience, right?
What does it mean?
It means increasingly responsible. It means, every day you're a little bit more greater in stature, if you want to interpret it very, very literally, It's, you've moved from a lower level to a higher level during the course of that experience.
Mm-hmm.
Yeah.
That's very interesting. So with progressively responsible experience is required to be in the EB2 category, right?
Yeah, based upon a bachelor's degree, yes.
Okay. All right. So now, go ahead. I wanted to clarify this for our audience.
So, what if your labor certification, doesn't say that? For one thing, that's a question. Some people don't put that language in there. And that's something, for me, it worries me whether USCIS can come at you later and say, well, it turns out we approved you in the EB2 category, but your labor certification doesn't require progressively responsible experience. Where still, they can do sort of a deep dive, even if your labor certification says, yes, requires progressively responsible experience, they can do a deep dive into your experience and question you as to whether it is really progressively responsible in their opinion.
So there's two things here you're discussing as I'm seeing it.
Yeah.
Do you agree?
I agree, yes.
So you're talking about, number one, there's background and foundation. To be in EB2, you must have a bachelor's degree and you must have a 5 years experience, and that years of experience must be progressive in responsibility.
Yeah.
That's the law. So that's foundation.
Yeah.
Now, first trap is if your labor certification does not use the word progressive. It says 5 years only and does not use the word progressive.
Yeah.
Now, do you think, and then the labor certification is certified, do you think that's a problem with the labor certification?
Well, so I've seen cases where USCIS in an I-140, for example, I've consulted on cases where in a context of an I-140, USCIS says, hey, show us that your case is your experience is progressively responsible.
When the labor certification does not list that?
I honestly cannot recall. It's been a little while.
So it's a vulnerability.
Yeah.
It's a vulnerability in your application that the government can come back later on. It is a low chance, but it is clearly a vulnerability because the word progressively is required in the law.
Yeah.
And if your attorney drops it and does not include it in the labor certification, there is a potential that labor certification can be revisited in the future.
Yeah, I mean, and how does it get revisited in the future? Well, I'll tell you how it gets revisited in the future. Say, hypothetically, you're required to file a second I-140. Perhaps you want to downgrade to EB3, like so many people did in October 2020. You're sending that labor certification back to USCIS, and it's possible that they were sleeping the first time, and then this time, they're really into it. And I've talked to people, more than one.
They're going to say, whoa, what's going on? The word progressively is not in your labor certification.
Yeah.
How can we give you an EB2?
Yeah.
You can go back and get an EB3 on that labor certification without a problem.
Yeah.
But you cannot get an EB2
yeah.
on that labor certification.
Yeah, and that's that. And you can't escape it. And even if your EB2 is already approved, if they bring up an issue in a labor certification, you're filing I-140, you're filing now, that gray cloud, if there's a gray cloud on that one, that gray cloud could, in theory, float over to your other labor certification.
So remedies, let's talk about solutions. So the remedy for something like that is to get the I-140 and EB3 filed, right?
Yeah.
And then you could file a new labor certification to remedy that, get it approved, and then get the EB2, add the word progressive in the labor certification, and then file the I-140 and EB2, and then get that priority date cross-charged, and that's wonderful, no problem, right?
Yeah.
And you can keep your priority, but it's a problem. So that's the first problem with the word progressive that we see. The second problem that you were talking about is when you're not able to prove it in your documentation during the adjustment?
During the hypothetically,
I-140 or adjustment.
I-140 or adjustment in theory, yeah.
You got to show progressive.
Yeah.
And how do you show progressive?
That's tough. I mean, basically, I think you really just sit there and, hopefully you have letters from, if you have multiple employers over the course of your required experience, your 5 years, you can probably lay out and plead the case and say, hey, I was a junior guy here, I was a medium guy here, I started getting some management responsibility here, and by this point I was a project manager. Those are the sort of things you can make, but it's challenging so far after the fact. Say if you're relying upon employment experience letters from a decade ago, and they weren't very good, they weren't very detailed, and they weren't very nuanced about your role, it's a serious challenge.
Yeah, and as you and I have talked before, you were saying also increase in salary, if there's a significant increase in salary through time.
Good point, yeah.
Clearly, it shows progressiveness. I mean, money talk. Money talk. Nobody's going to pay you more because you're funny. They pay you more because you're competent or you're more competent. So progressive, but if you are unable to show increase in salary, let's say your salary was plateauing for like 10 years, and also the experience in the title is plateauing and you're not doing more, that's a vulnerability to your case.
Yeah.
Okay, so the progressively responsible for bachelor's plus 5 years experience has traps in it that you should be aware of. Those are good ones, Brian.
Yeah.
What else do we got there?
Well, it's another perm-related question. Is what about typos in your labor certification?
Oh, yeah.
The popular spot for typos is in your employment history.
Well, typos or errors. I mean, let's be blunt about this. I mean, you or were you keeping the error in this later?
Typos and errors, you can use them interchangeably.
Okay.
The bottom line is when you sign off on that labor certification, your perm, you're signing off. It says on there that you're swearing to the truth and accuracy of the information in there. What happens if it turns out not everything in there is, well, you thought you were being truthful, but not everything is accurate?
Well, so obviously, based on what you said, my answer is it depends, right?
Yeah.
It depends on what it is.
Yeah.
So where does it most of the time?
Well, in so many questions of the law, the line is really materiality. I think most people would make the argument whether it matters, whether it impacts whether or not you are eligible. Yeah.
What about employment date, error or misrepresentation? You had a gap, or your employer, you transfer your H-1B, and your employer said, I need you a week earlier. Just start a week earlier, and you do. Or your employer was not very forthcoming, and most employers are great, some employers aren't, and lied to you and said, I filed your H-1B. You believe them, and you start working, and then you realize that the H-1B was filed a week later. Now you worked 1 week without authorization. Now you're nervous, then you hide it by putting wrong dates. This is, by the way, an actual case. I mean, all those things we're talking to you guys about is actual scenarios.
Yeah.
In cases, I mean, Brian and I have been doing this for quite some time, and we do see those issues. So anyways, so you see, and then you have now discrepancy in the date. Employment begin date is not real. You sign under oath that October 1st is my employment begin date. Actually, it was September 15th.
I see there's multiple potential issues. Is your labor certification any good, right? And is your, your labor certification, there's an argument to be made if you have the experience. As long as you have the experience you listed on that form is, your actual experience is sufficient to meet the requirements of the labor certification. You can make an argument that it's immaterial to the labor certification. Your labor certification should still stand. However, what, fraud or misrepresentation for immigration matters, though. You are trying to hide a violation in your employment history. That can, render you ineligible to immigrate to the United States. Fraud or misrepresentation. So, I mean, those answers don't necessarily have to line up, but I could just as easily make an argument that your perm is problematic as well.
How to fix it?
Well, it is potentially, going through the labor certification process again.
Yeah. Would you? So if the I-140, let's add to the scenario a little bit. We got a couple extra minutes. I know you have a few other scenarios, but we'll stop at the half and answer questions. But quickly, if the I-140 is filed, and with this bad labor certification,
yeah,
would you use that priority date?
My conservative answer is no. That's something I've told people before, and I usually preface it with, I know this hurts like 4-letter word of choice to say, but if you were to want to really clean things up, abandon that priority date and call it done, do entirely new labor certification and new I-140, wipe the slate clean.
Yes. The last trap, which is probably not a trap but an unfortunate scenario, is when, and now with the rush to approve green cards in the last year, the government has, as to be expected, honestly, have approved green cards incorrectly in some cases, and then they go into rescinding, going through a rescission of their green card process, and or the law also built in the ability for the Labor Department to rescind the labor certification after the fact.
Yeah.
And going through that process.
Yeah, for me, it's the ultimate answer. You know, if I just sneak by, can anything be done? They've issued me a green card. I've got my green card, and can it be undone? And the answer is yes. Mm-hmm. You know, it's not very often that it comes up, but sometimes, you mentioned right after 9/11. USCIS started opening up a lot of cases and going back to check their work and telling people, oops, we made a mistake and you're not eligible.
Was not USCIS.
INS, excuse me.
Yeah.
INS.
INS. And yeah, they have reopened cases. Yeah.
Yeah.
The Trump administration spent a lot of money reopen naturalization cases. Also trying to revoke naturalization. So the government can go back and reopen files and rescind within 5 years the green card, and that's why. And they have done it, and we have seen it. It's not fun.
I mean, what really worries me is the potential. Hey, we approved you in the EB2 category, but you didn't have an offer in the EB2 category because USCIS seemed to be playing fast and loose with hey, we'll approve you in the EB2 category if you just send us a letter saying so. But that's not the requirement. If you don't have that EB2 offer available and they go back and find that, we've heard them talk to people. We've heard of consulted on cases where they issued a green card in the EB2 category. They say, looking back, we realized you weren't eligible. You're only eligible for EB2, EB3 because that EB2 offer left. We're going to be taking back your green card. We're going to put it back into processing. We'll see you when your EB3 priority date is current.
Interesting stuff.
Yeah, for sure.
Yeah, interesting stuff. So hopefully this was helpful. It gives you some idea to some of the difficult issues that we deal with every day. When we come back, we're going to be answering your questions. All right, this is the time when we take your questions and trying to answer them, and hopefully we can, help bring about general answers to questions that you have. One of the things that I should let everybody know that these are general answers to general questions that the community has, and most of them kind of look the same, sound the same. Every once in a while we get some good questions that are kind of a little bit different, but we want to try to answer as many of them as possible. Just remember, there's no attorney-client relationship is established by this law firm answering your questions on this 1 hour that we spent together. And always consult with a qualified attorney of your choice anytime you feel that the situation merits a decision. Don't make a decision by listening to us and then go make a decision on your case. Consult with your attorney, hire a qualified lawyer so they can guide you and help you out. And without further delay, let's jump into that first question from...
Well, this isn't a question, but I like it anyway. Happy Halloween.
All right.
It's Halloween.
Yes, it is Halloween, and I think I am happy that candy is leaving my house today. I overdosed on candy already. As you can tell, I'm fired up here today.
I won't be dallying here after I've done this presentation because if my wife said, Brian, come home, I don't want to be answering the door every 5 minutes by myself. So I'm going to be jetting out of here to hand out some candy to the kiddos.
That's wonderful. Happy Halloween to you as well.
So this is talking about the CIS Ombudsman's webinar. So during the CIS Ombudsman's webinar, it was stated that EB1 has 46K and EB2 rest of the world has 41K pending cases. How does this affect spillover visas coming to EB2 India, where at least 40,000 cases are pending?
That's a great question. We did listen to the Ombudsman webinar and made notes. I did not go back and revisit our chart, which probably doesn't take too long to do.
Yeah.
To answer that question, but that's an excellent question that I would like to maybe spend some time later on and look at look at these numbers. Obviously, the first quarter. So remember, everybody, the first quarter number is there's not going to be any spillover. Well, there's not going to be any fall across or fall up or down consideration. That always happened at the end of the first quarter. And we move on. We're only dealing in the first quarter with the 7% of the 28% in the EB2 of the approximately 200,000. I know they're a little bit less than 200,000 green cards that are allocated for employment based. When the second quarter comes in, which is January, then you got to look at that. These numbers of 46,000 in the EB1 and see how much is that going to be cross-flowing. I haven't gone back and looked what we've estimated, but I think at a certain time we will and share this information. But that's a good point.
I mean, for me, I looked at that 46,000 number. I said, "Wow, that's way higher than I expected in terms of of their inventory." And the bottom line is, if EB1 is using those green cards, that's for me, a very simple answer, not having gone through the charts, is to basically say more EB1 green cards is less that flows down to EB2. You know?
Yeah. So I mean, so we have to look at what's a 28.6% of 200,000.
Yeah, and
does the calculator jump here if I push that button?
No, but here I'll go ahead, Sam, and type in calculator here.
So what's the 28.6 times?
0.286 times 200, give or take.
Yeah. So that's 57,000. That leaves 17,000 to fall down.
Yeah.
Well, 46. No, it is 10,000.
Yeah, about 10,000.
10,000. And I don't know what was the assumptions I had, but that is, I think, less than.
Oh, really?
And just remember, by the way, if there's 46,000, 46,000 pending in the EB1. EB1, by the way, is a category that has a little bit higher rejection rate.
This is true. Yeah, that's a very
than
good
EB2
point.
and EB3. It doesn't mean that all of them is going to go through.
That number. So, bottom line, that number struck me as surprisingly high. But ultimately, you're right. You got to go run by the numbers because I want to start comparing those EB1 numbers versus prior years.
So
too.
57,000 allocated for EB.
Yeah, for EB1.
EB1 across the board, and then so about 10,000 is going to fall down to India, which looks like less than what we were anticipating, but we'll see.
Yeah. So here's a question from Ati.
A previous employer filed my 485 under EB2 India. By the way, your previous employer did not file your I-485. You filed your I-485. It's your application by law. The employer shouldn't even see the content of it. Yeah. We tell our employers that we will not share the content of your employees' 485 because it has information that are private to the employee, because we are now in a dual representation and there's a bright line between that file and the green card file for the employer. But that's not the question. Let's go into the question.
Yeah.
You filed an I-45 under EB2 pursuant to an approved I-140 from your employer.
Yeah.
Currently not working for them, okay? Your priority date is March 2013. Can I change to a different employer than the employer who filed my 485 after 6 months? After 180 days of the 485 filing, you can go to a same or similar job classification. I'm assuming the I-140 is approved.
If the I-140 is approved, your I-45 has been pending for more than 180 days. I mean, devil's in the details. Always, talk to a qualified immigration counsel before you're making an important decision.
Yeah. So this is a scenario which is an excellent scenario for consultation with a qualified attorney. Because it really goes into the details, and at least in our office we do so much of those, and I'm sure other attorneys do the same. We go and break it down to the highest level of details to give you guidelines.
Yeah, I mean, the thing that what I would want to talk to somebody about on this is, Okay, so if you haven't worked for that company since you filed your adjustment of status. Well, I mean the details aren't here, but out of October 2020, when somebody filed an I-45 through an employer they weren't working for, well, first of all, those people were more likely to get interviews, in my opinion, and as I saw. And secondly, I think the inevitable question is, did you have an intent to join that employer in the first place? If you filed the I-45 through them and didn't work for them after that point, it's a legitimate question, which is kind of like in this part of this trap presentation. Can they in theory ask you about that? And I would just basically say to that is,
But I also, I'm not sure saying that it is the fact, but I am bringing a potential unemployment situation here. And if there's an unemployment situation and the priority is March 2013, might move quicker than you think, and you could be called for an interview. Should self-employment green card be a scenario in which you can prepare for in case you weren't able to find employer somewhere else?
Yeah, so the facts aren't all here. Always I say devil's in the details, but I mean there's definitely options here, that's for sure.
Yes.
Here we are from Momo Lee. Hello, please tell steps to start a company EAD and can sponsor my spouse's H-1B so she can change jobs and not use the EAD. So basically, starting a company on EAD and sponsoring my spouse's H-1B. So
that's not an option that is, I mean, let's put it that way. If you start a company and you have many employees and that company sponsors your wife on H-1B, I can see that working. If you have a one-man company and you apply for an H-1B for your wife, I just don't see a path for approval.
Yeah, that's like a conversation for me where it starts with, well, in theory, and then I think about 10 different reasons why that doesn't work very well.
It doesn't work very well, unfortunately. So, I mean, I know that there are people who have a company, IT company, for example, who have 50 and 60 employees, and the spouse is one of the consultants working on a project or a cousin. That's not a problem. I don't have a problem with it. But when you have one person, is that difficult?
I mean, I think for this presentation, how to start a company on EAD and get whether that's even feasible is probably more an hour-long conversation for me.
Yes. Do you see any new unexpected information in USCIS frequently asked question update done on October 26? I see only more explanation about the same things.
I would agree with that. So, after that ombudsman presentation, we were talking, internally about it, and I said, we talk about, things, what things that we could be presenting here, and I said, well, the ombudsman presentation didn't have a ton in it, and then I say, how about the FAQ? They said they updated the FAQ, and basically, I scrolled through the first, the updates to the FAQ, and I said, nothing really here, nothing new and crazy.
Can an alien port to self-employment working in the same occupation with an approved EAD card while waiting for I-45, while final action date not current? Will this put green card approval in jeopardy? Can an alien port to self-employment working in the same occupation with an approved EAD card while waiting for I-45? Yes. Mm-hmm. While final action date not current? Yes. Will this put green card approval in jeopardy? No. You can elaborate.
So, when I talk to people, I'd say, I usually tell people, there's the most conservative way you can do things and the least conservative way to do things. It is entirely possible to switch to self-employment, but, I'd say, it's easier for them to question self-employment versus, working for an established company already, I guess. It's definitely a situation you can do, and something we've helped people do in the past, for sure.
One of a very reputable architectural firm in town, where a husband and wife both were architects, both were on H-1Bs, both working for an employer, both were laid off at the same time, and both had pending green card with EADs. We helped them start their business. And what we did is we put the company on one company's name because they had two of them, so you could have done it either way, and there was no problem. And this story is over 15 years old. This story I'm sharing. This business is viable. They're doing great. So I'm not worried about success. It is not our last resort. It all depends on you and your personality. If you're aggressive,
devil's in the details. If you got a business that is booming, sure, I'm gonna say. Well, it
doesn't have to be booming for approval.
Okay. Booming for me is it's sustaining your life. It's keeping you going. It's paying you an appropriate rate for compared. It's putting you in its occupation same or similar to what you were previously doing through your I-140 sponsor. That's the bottom line.
And you're making at least that money in that labor certification, or more. But if you're making less, I would be worried about it.
Yeah,
absolutely. What are the chances for EB3 India final action date reaching November 2014 by July of 2025? That's a great question.
July of 2025 is now, that's about, oh boy, a little bit, about 2.5 years from now. That's
July 2015 is when my daughter would age out after applying for CSPA calculation. I honestly don't have an honest answer.
EB3 India final action date November 2014. So
it's very likely, but it's because right now we're April.
I know we're in April 2012, but I want to stare at it so I can think about it a little bit more. That's a year. That's a year and about a year and a half of visa bulletin movement. I don't know. Do you believe EB2 will move faster than EB3, Sam?
Yes.
Okay. Well, that's what I think about for somebody like this. It's see if it's possible to get into the EB2 category. I don't know whether it's possible for you, whether you can meet the requirements. But an EB2 case with a nice, long pending I-140 might buy your daughter a little bit more time. Think about that, Sam. A new I-140. I don't know whether you're for the purpose of the Child Status Protection Act, the time your child has is based upon the pendency of your I-140, right? If that EB3 one was approved in premium processing, 14 days. But if you did a new EB2 one in the future and took them a long time to approve it, you could, in theory, buy your child some more time. And being in the EB2 category might, in theory, make that priority date come up a little bit faster. Just what I think about.
Excellent analysis. Thank you.
Way more analysis than that person asked for.
But that's wonderful.
Yeah.
My priority date is February 2014. Based on transfer underlying basis, my EB3 got upgraded to EB2, and also I received Supplement J approval notice. Will there be any chance to get green card in 2023 or 2024? My case status is now CRP. So it's one of those prediction questions.
February 2014. I don't think it's so crazy. 2024. I mean. That's the problem. So the fundamental problem that we have is the rest of the world. USCIS says the demand from the rest of the world is so high that they're going to be backlogged, right? And if they're backlogged, it means there won't be overflow into EB2, right? And as everybody surely knows, the amount of visas that will go to India without overflow from other countries is abysmal. And that's what we are kind of waiting to play out. I mean, one of the things I recall from the Ombudsman seminar is they very much emphasize that, they're anticipating they see the high rest of the world demand right now, but they evaluate these things on a quarterly basis. So, and that's when the visas, get allocated. So I am very anxious to see that January visa bulletin. It will give us an idea as to what's really going on.
We're going to look at these numbers. I mean, they're sharing some numbers in terms of available EB1s, so we can probably have a reasonable January prediction.
Yeah.
More information, data is trickling out.
Yeah.
I'd like to see who in the heck is applying for EB1 and what's the likelihood of approval for those cases.
Well, that's something I don't think we're ever be able to calculate. But
so what's the employment-based special exception, Brian?
So on the USCIS FAQ, updated 1026, it talks about special exception to per country levels for employment-based categories. Can you please explain how it works?
I don't remember the special exception.
Yeah, and I read that FAQ. I mean, that's the sort of thing where it's. I'm not quite sure what they're referring to. I would agree with you. I'm not quite sure what they're referring to. Special exception for employment to the per country levels for employment-based categories. I'm not sure.
Yeah, I'll be interested to see it. I mean, there's nothing in the law that create exception except the fall across and the fall down.
Yeah, I mean,
those are the exceptions.
Maybe I'm thinking of visa movement amongst categories as well. I was thinking maybe if they fall over from family preference.
But that's not exception.
Yeah,
it's not exception. That's a calculation method.
Yeah.
All right, we'll look into it, and maybe if you remind us next time, we'll answer that question.
Yeah.
I just made a note right here that we're going to look into that.
Yes. So here we go. Here's a question from Narayan. I can't speak today.
Narayan Mota.
Yes, thank you, sir. EB3 priority date January 6, 2014. Filed in October 2020. Got EAD last year along with my daughter. Daughter turns 21 in February 2021. Any option can she be covered with me? I'll
be curious. So what's the most forward filed October EAD? So EAD, when he says EAD last year, that tells me that an adjustment is filed.
Yeah.
And whether or not, I don't remember. I'm trying to remember whether
I don't think EB3 made it that far forward in terms of final action
January
dates.
2014.
Yeah, I don't think it made it to final action dates.
Yeah.
Yeah.
If it did not make it to final action dates, ouch.
Yeah.
The only possible, so EB3, right? So the only possibility, I don't know the facts of this case, is if there's a potential EB1 concurrently filed, or a potential EB2 concurrently filed. No, not EB2, but EB1.
No, I don't see it because this daughter turned 21 in February 2021. She's already 20.
Oh, already 21.
Yeah.
Turn 21 in February 2021. Any options go? Yeah, you got to look to it. You have to look to it. It's worth looking into because it definitely she gets some credit on the I-140 filing timeline.
Yeah, that's a good point. Yeah.
But maybe there is a potential filing in EB1 or something that can lock her in potentially. It sounds like it is. I mean, nothing I can read here that can add. She moved to F1 now. Yeah. Nothing I can read gives me an opportunity to give you hope, let's put it that way.
Yeah.
But doesn't mean that your case is, I can give you a definitive answer here for sure. You need to really have somebody look at it for you.
Yeah.
One and only trap in green card process is country caps, end of the story. There was a wonderful article about, the title was, the employment-based green card is the biggest bait and switch that the government pulls on immigrants. Brings you in with a promise for a green card and then have you come here, build your life here, have your children here, buy a house, and they say, okay, wait here for 10 years.
Yeah, or 10 years if you're lucky. I mean, there's people here. I've talked to people that. So, Sam, my response to that, I remember you told me about that article you had read, and my response was, well, Sam, for me, at least I try not to leave people, surprised. I tell them, people ask me at the beginning of the green card process, how long is this going to take? And then one of the first the questions I ask is, are you familiar with, if you're from India or China, are you familiar with the visa backlog? And, don't. It's really. You're right. Absolutely, I agree. I tell you a little story. So there was a time when the Department of Labor was giving a prevailing wage in a week and certifying labor certifications in months.
In a month.
Yeah.
Okay. And I had a case, guy not born in China or India, where the guy got his green card in 8 months because the I-140 was in premium processing, the I-485 was filed, and things moved. And he was so happy, he tells everybody, this attorney is so good, he got my green card in 8 months. It's not me. It's not me. It's the process. You're stuck. We are also, as lawyers, victim. I'd love to get a green card handed out to everybody in 8 months and move on. But these files sit in our office for a decade.
Yeah.
I lose hair, my hair turns gray, I gain weight, I get more wrinkles
Quit describing me, Sam.
before I get to the next approval, which is frustrating for me as well.
Yeah, it is really quite, yeah.
If you file labor, every time you make a big jump, forget your green card.
So I think, I'm going to fill in some gaps there. We're talking about, filing a labor every time you make a big jump in salary. And nobody's saying you're required to
No.
Yeah.
Well, it all depends on what's a big jump. I mean, I've had scenarios when somebody got paid $100,000 more. That big jump, you can ignore filing the labor and go in for the adjustment interview, and good luck. That's a decision your employer and you can make. I have no problem with it. But if you've made a 10 or 15% increase, 20% increase in salary, I got no problem.
I mean, there's also all sorts of good fact scenarios there. I mean, what if it's just a temporary jump? You're on a temporary assignment where it's a big raise. That's not what necessarily affect your green card application. But it's not a problem to redo. It's not very often that we have to redo labor certifications for people, but it happens. And you get to retain your priority date. You still get your green card in the same time frame. It's just you might have to go through the labor certification process again.
Yep. Love the thumbnails for today's video. Cheese on a mousetrap.
Well, yeah.
Credit Brian.
Sometimes those thumbnails are really easy to come up with, and sometimes they're really hard to come up with. Thank you. I don't like that. That's the metaphor that I'm using for our immigration system, though. It's upsetting.
It is what it is. How many green cards do you think EB2 India will receive this year with spillover, and you think a final action date will go to December 2014 in the next 3 years? We haven't done the calculation since the Ombudsman video release with these numbers, which is probably worth looking into.
Yeah, I think we might be required to revisit the numbers.
Maybe we'll do a
we'll
do a revisit to get the facts together. So, guys, I know we've taken good notes. If somebody recorded that Ombudsman, our recording failed for some reason, it didn't record. But if somebody recorded the Ombudsman presentation,
shoot us an email.
Yeah, send it to us because I'd like to kind of do a deep dive, because I don't want to take numbers out of context.
Yeah.
When I listen to the more than one time. So if anybody's recorded it, send it to us.
Please do. Yeah.
We would appreciate it. Also, do you think any bills likely, like the Eagle Act, may get passed?
Well,
Yep.
there's a reason why this time last year was it, that we were talking about all the interesting bills bills in Congress, particularly the Biden's Build Back Better, because it seemed really, really close.
Yeah.
When we get this excited about something happening, we'll be talking about it here because that's, the core of what we talk about here.
Yes.
Yeah. So I guess we don't really have much optimism right now.
Brian, take that one.
So, hi, GE. At what time a primary applicant adjustment of status application is considered abandoned when the primary applicant moves out of the USA? Say after 90 days or 180 days or 1 year. Thank you.
Fantastic question.
Yeah, this is a great question. We were talking about this recently. I can't remember the context.
Well, do you want to? Well, I'll start. Number one, there is nothing in the law that defines a number of days. That's the starting of the analysis. Mm-hmm. If you leave the country with a valid advance parole, my argument would be, as long as that advance parole valid, and as long as the offer of employment, future employment is there, your adjustment of status application should be considered in good shape.
That's where I wanted to jump in. It's the offer of employment. If you are, devil's in the details, if you are on assignment, with your employer, in another country, and you're not in the United States, and they say, yeah, we have a job for this person here. That's a scenario I like. Come back to the United States anytime for you. But if you're just, abroad, on a nice, perpetual vacation, you're not doing anything, I guess the point is you have to have that job offer. there's no requirement that you be in the United States while your I-45 is pending.
Especially if you had an H-1B valid and you maintained it, that's more evidence that you're leaving on a temporary assignment. Now, if you've lost the employer and lost your H-1B and did not get renewed, and you've closed your bank account and you've lost your job offer, that's a problem. But let's assume you renew your H-1B, you have an adjustment. And by the way, we have this video on H-1B beyond 6 years, because if you file your I-45, you can renew your H-1B 3 years at a time, or you can transfer it to a new employer. And there is a link to it in the description that you can go back. It's important that you understand the nuances of extension beyond 6 years, because that dovetails very well with some of the issues you guys are dealing with. But let's assume you lose your job. Let me change the facts a little bit here. You lose your job for 3 months, adjustment pending, retrogressed, and then obviously there's an adjustment pending, and Harry watched your amazing 6 years beyond H-1B beyond 6 years video and said, I can get a new H-1B with a new employer. And gets a new H-1B, comes back in, and then file for portability, I-45 portability.
That's fine,
And then he can revive that green card application. So understanding your ability to come back.
Yeah, usually if I'm talking to somebody, even if somebody who hasn't filed for adjustment is yet they're outside the United States and their priority date is current, I'm usually, or going to be current, I'm usually talking to them about terms of, hey, come back to the United States when your green card is ready to be approved. You know?
Yeah. So it's fact driven, but it's an excellent question.
Yeah.
701, we'll take one more. What is your take on priority date of May 2013? Any likelihood of getting current in 2023? I would say yes.
I give a hope and pray on that one. You know, I'm always happy when it moves forward, and I think that one's not so crazy.
Yes. Well, happy Halloweens, everybody. Thank you for listening to us. Come back next week at 6 o'clock for more of the